So I'm going to do a quick flip of the order, and I'm going to introduce one of our panel openers, Desiree Jones-Mathias. And then following that, I'll introduce our moderator, Maria Dugas. So Desiree Jones-Mathias is an African Nova Scotian woman from the historical Black community of Upper Hammonds Plains. I'm waiting for it. There we go. She holds a Bachelor of Arts in Sociology with a minor in Law and Society. She graduated from the Schulich School of Law at Dalhousie University in 2020 and was admitted to the Nova Scotia Bar in 2022. She articled with Nova Scotia Legal Aid prior to joining ANSJI in July of 2022. Her practice focuses on criminal defense, human rights, and social/racial justice policy reform. Her work at ANSJI is centered in increasing access to justice for Black and African Nova Scotian clients in need of legal services. ANSJI takes a collaborative approach, developing various partnerships with other community organizations and institutions to provide wraparound support to those in need and to advocate for changes within the legal system. Ms. Jones-Mathias has been awarded, so there's a couple of awards here, I'm gonna read some of them. Told you, I read the bios. Ms. Jones-Mathias has been awarded for her high level of community commitment and service. She's a member of the Upper Hammonds Plains Community Development Association and the Canadian Association of Black Lawyers. In 2020, she received the Judge Corinne Sparks Award and the Nova Scotia Criminal Justice Association Student Award, both of which recognize her commitment to using her legal education for the benefit of the community. And finally, she served as Vice President and Community Liaison for the Dalhousie Black Law Students Association. And she was appointed to the Nova Scotia Barristers Society Racial Equity Committee in January 2023 and was elected by her peers to represent the Halifax District on the NSBS Council, starting her 2-year term in June 2023. And last, Desiree was appointed to the provincial government's Environmental Racism Panel in June 2023. And as I say to Desiree all the time, Desiree Jones-Mathias, that name rings bells in the streets. Welcome, Desiree.
Thank you very much. Good afternoon, everyone. I thought I was speaking for 2 minutes and not 10, so I'm going to keep this brief so I can buy some time for what's going to be a very important discussion with our panelists on this next panel, speaking about the fair treatment of African Nova Scotians policy that the Public Prosecution Service just rolled out. So the first panel that we heard set quite the foundation for this one. The previous discussion let us know why we need a policy, this policy in particular, to guide prosecutors to give fair treatment to African Nova Scotians involved in our criminal legal system. As Michelle had stated, the law has been used to oppress us. That's a fact. It takes defense lawyers and it takes prosecutors to use our legal training to enforce the law towards our collective liberation. This is an active effort. It's not a passive one. The law does not change itself. We have to, as legal system actors, do something to address issues of over-incarceration, for example, because if we don't, this is how systemic racism works. If we do nothing, this machine called our legal system keeps operating as it was created to hold us down and to oppress us. Without impact of race and culture assessments, IRCAs, for example, we continued to see unequal outcomes for Black folks at sentencing. And without this policy, we continue to see Black accused denied bail at unequal rates and continue to see Black community members before our courts time and time again. This event, this discussion, this policy is really a first step, a big step towards transparency by the PPS, the Public Prosecution Service, to the African Nova Scotian community. And I commend PPS for that and your willingness to participate today. And to bring my friends, as we call ourselves in court, AKA the other prosecutors, with you as well today. It's nice to see a few of you in the room. This policy is a step towards transparency because it gives us what the expectations are. Prosecutors are strongly encouraged to consult with the Equity and Diversity Committee, it says. Strongly encouraged to consult with the Director, Executive Lead of Equity and Inclusion, it says. But I'm still left asking, are there any mechanisms for accountability with this policy? because policy without accountability puts us at risk of continuing to operate within the status quo. I'm speaking to community members when I say this is a public-facing policy. It's on us to hold the prosecution service accountable and make sure that this policy is working in practice and on the ground. We have to ask who is to intervene in particular cases when it is clearly not being followed. So right now, it's on us to do that. We as a community have to be informed on this policy, educated about what it says, what it means. And this should be the main goal for us today, to equip community with the means to advocate for our family, for our children, our nieces and nephews, our friends, our cousins, our community members, to make sure that this policy is being followed and actually producing results that are equitable. So we come together today to openly discuss how this policy can make a difference in the lives of those African Nova Scotian community members who are forced to interact with the criminal legal system, often because of their circumstances and their historical backgrounds. So I'm very much looking forward to the discussion, and I'm sure the audience is as well. And thank you to the panelists for being here to discuss this extremely important and timely initiative. Thank you.
Thank you, Desiree. And next, I'm going to introduce our panel moderator. Maria Dugas is an assistant professor at the Schulich School of Law at Dalhousie University. She teaches African Nova Scotian legal history and issues in critical race theory, tort law and damage compensation, copyright law, legal research and writing, and guest lectures on anti-Black racism in the criminal justice system. Professor Dugas holds a JD and an LLM from Dalhousie University and is a proud graduate of the Indigenous Black in Mi'kmaq Initiative. She was called to the Nova Scotia Bar in 2016 after articling in the Youth Criminal Justice Office at Nova Scotia Legal Aid in Halifax. In 2017, Professor Dugas became the first African Nova Scotian to clerk at the Nova Scotia Court of Appeal. And her research interests are rooted in critical race legal theory, most recently addressing issues of anti-Black racism in the criminal justice system and professional sport. Professor Dugas is a 2002 recipient of Dalhousie's Belong Research Fellowship Award. Her project looks to address the presence and effect of anti-Black racism in the child welfare system in Nova Scotia. So please welcome Professor Dugas.
Sorry. Good afternoon, everybody. It's an honor to be here with all of you this afternoon. Excited, if not a little bit nervous, so please bear with me if I stumble through some of what I have to say today. I'm pleased to introduce our panelists for this panel. First up, we have Brandon Rolle, who I'm sure everybody is familiar with, but I will also read his bio. So Brandon is a graduate of the IBNM initiative in the 2009 class of the Dalhousie Law School and was called to the Nova Scotia Bar in 2010. He worked in private practice for a short time, then joined Nova Scotia Legal Aid in 2013 with a focus on criminal law. In 2017, Brandon was promoted to the position of managing lawyer of the Halifax Youth Justice Office. In March 2022, Brandon accepted a secondment to the African Nova Scotian Justice Institute. Brandon is passionate about issues of race and culture for African Nova Scotian and Black clients and continues to advance these issues in the courtroom and in the profession at large. Round of applause for Brandon. Next, we have Rick Woodburn, KC, who was appointed as acting director of the Nova Scotia Public Prosecution Service in late November 2023. Prior to his appointment, he spent over 20 years in criminal prosecutions. His expertise as a senior Crown Counsel was formed during work on numerous complex cases in such areas as hate crimes, sexual violence, human trafficking, homicide, and dangerous offender applications. In 2021, along with fellow prosecutors Christine Driscoll and Sean McCarroll, Rick was recognized nationally, winning outstanding achievement in a prosecution for the dedication and commitment they displayed during the prosecution of James Melvin through multiple trials and a lengthy dangerous offender designation application. Mr. Woodburn is an active volunteer in his profession and community and was the president of the Canadian Association of Crown Counsel for over a decade. He has presented expert evidence to the Senate Committee on Legal and Constitutional Affairs and is also an active mentor for both high school students and those looking to begin their legal career. Since his appointment, Rick has prioritized EDIA initiatives, working with the Director, Executive Lead, Equity and Strategic Relations, EDIA Committee, members of the Public Prosecution Services Executive Team, and community, government, and sector partners. In February of 2023, Rick oversaw the launch of the Fair Treatment of African Nova Scotian People and the People of African Descent in Criminal Prosecutions Policy. Welcome, Rick. And next we have Vanessa Fells. Vanessa was born into a large family in the African Nova Scotian community of Yarmouth. Pause for Yarmouth. Her family believed that in order to support our community, you need a good education, economic freedom, and to be a critical thinker. Taking this to heart, she completed 2 bachelor's degrees and then completed a Master of Education in Afrocentric Policy in 2013. In 2015, Vanessa represented Canada at the United Nations Human Rights Fellowship Program for the International Decade for People of African Descent in Geneva, Switzerland. Vanessa then attended the United Nations Permanent Forum first and second sessions for people of African descent and provided recommendations for the UN Declaration for the People of African Descent. She was also the co-chair of the 2022 National Black Canadian Summit that took place in Halifax and was hosted by the Michael Jean Foundation. She currently sits on the Progressing Monitoring Committee for the Mass Casualty Commission, is a steering committee member of the National Black Justice Strategy, a board member of the African Nova Scotian Justice Institute and the African Nova Scotian Education Fund, and is a steering committee member for the RCMP Provincial Apology for Street Checks. Vanessa is dedicated to enhancing and achieving her community, and she is currently employed as the advisor of equity and access for the Nova Scotia Barristers Society. I think I'll join you folks over here, maybe that. Can everybody hear me? Perfect. Okay, so welcome everyone. We're going to do a bit of a moderated discussion with the panelists and then open it up to folks in the audience if there are questions as well. To get us started, this is a question just for the panel, so feel free, whoever would like to jump in first. How do each of you, in your respective roles, contribute to the fair treatment of African Nova Scotians within the justice system?
I can jump in on that one, and I think it's the work we do every day at the Institute. I don't have to look very far to see shining examples of that, but I do want to say something before we begin, and I'm glad that Desiree sort of grounded us in the importance of this work. We're going to talk about some positive developments at PPS, which I think are things that should be focused on. But the reality is that PPS is an organization that historically has been harmful for African Nova Scotians. There are people in this room who have been harmed by PPS. And so this opportunity to have the director with us, which I don't think has ever happened before, and this engagement with community is extremely important. And if you haven't read the policy, or at least the policy summary, I would strongly encourage you to do that, because it is an opportunity. We talk about accountability. It is an opportunity for community to have input, to have a say. And this is a very, very important discussion. If we think about challenges in the criminal justice system, having this discussion at this time is extremely important. So I thank you for the opportunity to be on the panel, and I will talk about our work. I just wanted to say that first to ground us in that understanding that this is a really significant time. So the work we do every day, is about the fair treatment of African Nova Scotians. I got a text this morning from Desiree Jones-Mathias, client found not guilty in Dartmouth Provincial Court. And that's the kind of work that Desiree has been doing since she started. I think about her arc going through the IBNM initiative with professors who are engaging in critical race theory, coming into the profession and learning at a place where she can take the time to devote to these files, to bring a lens to, of critical race to those files, identify them, not only for prosecutors, which we'll talk about more, but for the courts. In that case, for example, it was an impaired case, and one of the indicia of impairment was slurred speech. Well, no, this was an older gentleman from North Preston. That's how he talked. That was his dialect. That's not slurred speech. So those types of issues that never historically have been raised in the courtroom are the types of things that we get to do at the Institute. We have a full-service criminal law division. We help people with cases on the ground across the province. We also engage in strategic litigation. Anderson was mentioned by Chief Judge Borden. Very monumental decision where the Court of Appeal said we are going to sentence Black folks differently in this province, recognizing overrepresentation in the criminal justice system, overrepresentation in custody. And part of our job is to protect that decision. Nowhere else in the country has decisions like that. And so we've appeared at the Court of Appeal twice, and 2 times the Court of Appeal has said, we meant what we said in Anderson. This is the law here. And later on this year, the Supreme Court of Canada is going to weigh in on a case that's going up from Ontario. They're going to talk about IRCAs, and we will be at the table, again, to protect the work that's happening in Nova Scotia. So beyond the full-service law firm that we provide, we're a place that teaches as well. We teach students. We engage with the Schulich School of Law now, Dalhousie Law School when I went there. But that critical race theory work that was mentioned earlier, Professor Williams, Professor Dugas, Professor Marsman, incredible. People now, that's mandatory. You have to take that at law school. These folks are coming into the profession with a higher bar in terms of critical race theory understanding than exists with people who are practicing right now. So that's encouraging, and we support that work by presenting with those folks and teaching at the law school. We are also teaching the profession. We're teaching our colleagues. We're also teaching judges. We've had the opportunity to present to judges not only here in Nova Scotia, but across the country as well. So, it's so important. The work that has started here is grounded here in Nova Scotia. And I want to thank community for coming today. This is heavy work, and it's work that takes a toll, and we gain our strength from community. I look out and see people that I gain strength from, and it's so important that you're here today, and I'm looking forward to a really engaging conversation. So I'll give some space for other folks to answer that.
I completely forgot the question, I'll be honest. Yeah, sorry.
I was just going to offer to repeat it for you.
Thank you very much. Yeah.
So how do you, in your role, contribute to the fair treatment of African Nova Scotians within the justice system?
Oh, that goes back a while. Yeah, I'm going to age myself here. I guess it's always been part of my family. I was in education for like 20 years, so in terms of the fair treatment of African Nova Scotians, have always been an advocate in that aspect, and understanding that education, and we talked about that this morning, is really that building block and that foundation of changing policy and changing society and community. And the roles that I've had since then, we did a lot of work on street checks, and I see many of you who sat around the table for hours as we talked and strategized on that, racist practice of street checks and the harm that it caused to the community, and how we felt when, as a community, street checks were banned. And that is a long time coming, because if you know the history of street checks, again, I'm an education person, so I'm always going to talk about it through a historical context, but if you know the history of street checks, it goes all the way back to the race riot of 1784 and the Black Loyalists, about policing Black bodies where they can and cannot be. And then you bring it all the way today to when street checks happened. And again, it's a new reiteration of policing Black bodies. So changing policies like that are really what is near and dear to my heart. And now at the Nova Scotia Barristers Society, it's again looking at an organization that has been around since 1825. In 1825, we weren't even emancipated yet. That was 9 years later. So if you think about an organization that was established during peak colonialism with still having enslavement, yeah, there's a lot of issues with anti-Black racism. Of course there are going to be issues. So having those open conversations are extremely difficult, especially for an institution that has been around as long as the Barristers Society has been around. But having the courage to stand up and say, there's a problem. We have been part of this problem. So now how are we going to change that direction, have those conversations and change that policy? So that's where I am today.
I'm going to have you turn my mic off. Rightfully so. First, I want to thank you very much for inviting me here. And I want to say that this is a difficult conversation. It's a difficult conversation to have. And we should be having it. And I'm glad to be here. And as hard as it is to have these kinds of conversations, I'm happy to be part of it, and I'm happy you invited me. Part of this policy, when we rolled it out, we wanted to do it in person at the Black Cultural Center. It's the first time that the Public Prosecution Service has ever done anything like that. This one doesn't work?
It didn't seem loud, I don't know.
That's because I was speaking low.
Oh, for a fact. My fault, Ray.
I was trying to sound like less prosecutorial and have maybe see my gentler side, which Brandon has never seen before.
You want me to weigh in on that, Rick?
No, not right now. Thank you. But just where I left off, where I'm not sure, but it was important for us to have that conversation. It was important for us to roll it out in person. Once again, the first time we've done anything like that. And they're not wrong. It's the first time that the director or acting director of the Public Prosecution Service has come and sat down to have the difficult conversations, and it is time. And I see, thank you. No, that was excellent. If I could have 100 more of those, that'd be great. It is time. It's time to move forward. It's time to make change. I can say this, and we're going to probably get it wrong, and then we're going to get it wrong again, and then maybe we're going to get it right. And that's what we're going to do. We're going to try. I'm not here to ask the community to trust us. I'm asking that we can be involved in a conversation about trust and how we get there. Somebody told me that we're probably not going to get there in our lifetimes, and I said, I'm going to live a long time. So, but we are going to move forward. We are going to try. We're going to have those difficult conversations, and I see my role as doing that, as championing this policy and moving the PPS forward. I think that's where I'm at. Thank you. And one more thing. Obviously, the institution, the Institute, has taught me a lot, and I appreciate that. So he mentioned the community, he mentioned a lot of people that taught. I'm learning a lot every day, not only by being here, but the meetings that we have with the Institute.
Before we get into a discussion about the policy, Mr. Woodburn, I'm wondering if you could talk to the audience a bit about the history of the PPS and its intended purpose.
Like Chief Judge, if I was a speed talker, I probably wouldn't be able to finish today. But I'll give you a rough outline. Can you hold the mic up a little bit? Sorry, I do talk loud. That's why I don't like to yell into mics. Sorry, I apologize. In 1990, as a result of Marshall, the Public Prosecution Service was created. It was the first independent, truly independent, statutorily independent prosecution service in Canada. What does that mean? Well, it means a lot of things to a lot of different people. I've spent a lot of my career talking to a lot of people about what independence meant, and especially with prosecution. In our particular case, we are to be independent from influence. Influence from where? From government, from politicians, from outside organizations. We are to be free of that, and we're to conduct our prosecutions objectively with the evidence that we have. And when you think about independence, people say, well, what do you mean by that? I give it this. if you're a friend of mine, and that's a hypothetical because I don't have any friends, and you call me up and say, Uncle Jed just got pulled over for drinking and driving, can you do something about that? Well, no, we're friends. You can't influence me that way. And if they say to me, all right, well, I'm going to call my MLA, and then they'll call you. Well, that's a definite no-no, because that's political interference. So when we look at the independence of our organization, we're independent from outside influences. So we are actually, when you look at in our province, the Minister of Justice wears two hats, Minister of Justice and the Attorney General. We actually fall under the Attorney General. And if there's any type of direction that's given, the Attorney General has to put it in writing and it has to be publicized so everybody can see, so we can have that transparency. So you're not thinking to yourself, well, is there something going behind the scenes that we don't know about? It adds to that transparency. Another thing probably, one, people don't know this, Crown attorneys are lawyers. So a lot of people don't recognize that, especially when they apply for jobs. We get a lot of applicants that don't have law degrees, which is fine. I'm not entirely sure if my law degree is still good. But we play a role where we're also independent, meaning we're supposed to be objective. That means we take the evidence and we present it in the most objective way to the court. Brandon, for example, is a defense lawyer and advocate for the individual that he's representing. The judge hears the evidence and makes a decision. So we each play our roles, and we're supposed to be objective, and we're supposed to be independent. Supposed to be. So that is the theory. We have policies that are public. The F10's policy itself was made public and presented publicly on purpose so that you could see, so we could break down some of those walls so that there could be some transparency in what we do and how we do it, especially when it comes to African Nova Scotians and people of African descent. So when we look at the policy, that supposed independence, that supposed objectivity, we start to see it a little bit more. We used to, are you looking at me like, time? No? Okay. We followed some of the policy guidelines, but they weren't written down. We weren't accountable. Nobody knew exactly what was going on. We were intentional. We wanted to make sure that everybody knew, whether it be the community, defense, the judiciary. That's part of what holds us accountable. And that's part of what we do at the Public Prosecution Service.
So I hear themes in there of independence, transparency, objectivity, and accountability. Mr. Rolle, I'm wondering from your perspective in the work that you do at the Justice Institute and the work that you've done at Nova Scotia Legal Aid, do you think the PPS is living up to its intended purpose, and why or why not?
So I think we need to look back to why the PPS was formed as an independent organization. Marshall has been referenced a couple of times. Chief Judge Borden talked about the failures of the system. Marshall was a 17-year-old Mi'kmaq teenager, wrongfully convicted of murdering a 17-year-old African Nova Scotian teenager, Sandy Seal. And Marshall was very much, obviously, about Donald Marshall Jr. It was also very much about the experience of Indigenous and Black folks with the criminal justice system. And in the inquiry, they talked about political interference, as Rick alluded to. But it was political interference that was working to harm Indigenous folks, working to harm Black folks. And in the inquiry, they did a comparison. They looked at two cases of affluent white men and how they were treated by the system and how political interference worked in their favor. And that is the reason that PPS was created as an independent organization. Unfortunately, and respectfully, from my position, what happened was PPS was given this shield of independence at the expense of accountability. And that was never meant to be the intention. Accountability was supposed to flow through the Attorney General, the chief law officer in the province, back to the public. And those mechanisms, over time, in my opinion, again, have been lost. So yes, you always need to have prosecutorial independence. It is important. But the objective system has been disproportionately impacting Indigenous and Black folks for decades. And so that system is not working, and that is why we needed something like the FTAN's policy. It was needed because there was systemic racism and discrimination happening, and PPS was a part of that. Other actors in the system are a part of that as well. There are some positive things that are happening, and those should be acknowledged. I look at my friend and colleague, David Curdy, in the audience. One of the primary authors of this policy, worked hard for years, along with other folks, Josie McKinney, Ingrid Brody, some other folks in PPS as well. David was recently announced as acting Chief Crown in the Western region. First time in the history. First time in the history of the organization that someone from the Indigenous or Black community has been in a Chief Crown position, Deputy Director, or Director role. That's over 30 years. And you can't tell me there weren't qualified people in there. I'm looking at some of them. You know, Judge Perry Borden worked there. Cheryl Byard worked there. Judge Alonzo Wright worked there. Judge Jean Whalen worked there. So those people were there and never promoted to those positions. And so as an institute, we have called out the actions of PPS on multiple occasions to say this has been harmful to community. There has to be a way that we can get at this that's meaningful for community. And I think the FTAN's policy is a good start. I think we also have to acknowledge that the first time that this was attempted, in terms of training, it did not go well. And community was involved in that, and again, harm was caused. So if I look since 1990, since this organization was started, and ask myself, is it living up to its intended purpose? I have to say no. I have to say no, and I have to say we can do more, and we are gonna do more, and this is a great start, but we're gonna ask some hard questions today, and I'm glad the director is here to take that on. And I encourage folks to ask those critical questions, not only of him, but of me as well, because we all play our part in making that systemic change, and we should welcome that opportunity.
Ms. Fells, another question for you before, again, we dive more deeply into the policy. Of course, the Nova Scotia Barristers Society has a role to play in obviously regulating the profession and help ensuring that our legal system is more equitable. Could you tell us about some of the work that you're doing with the Barristers Society to make things more equitable for the African Nova Scotian and Black communities? And if you have examples that you would like to share, that would be great.
I'll share 3 quick examples. We've currently received a Law Foundations grant at the Barristers Society, and we are in the beginning stages of developing an Indigenous Black and Mi'kmaq intern pathway program. And that will be for high school students, Indigenous and Black, who are thinking about going into the legal profession. It will be a 1-week internship that will happen March break of 2025, so coming up very soon. And we will bring students from around the province, both Indigenous and African Nova Scotian, people of African descent, and Mi'kmaq, here to Halifax for an immersive week of what it looks like to not only be a lawyer practicing, what it looks like to be an Indigenous or Black judge, a prosecutor, a defense, but also other things that you can do with a law degree, because not everybody practices. There are non-practicing lawyers, and what that actually looks like. So we are just in the beginning stages. We're putting together a program. We are very excited about it. The idea actually came from the CABLE, so the Canadian Bar Association, I can't remember the acronym. Anyway,
Association of Black Lawyers.
Thank you. The Canadian Association of Black Lawyers. The Nova Scotia branch actually first came up with the idea several years ago, and have since then, they have now partnered with us. So we have many community partners, including the Justice Institute, that are working collectively on this project, and we are very excited when it will happen. March break 2025, some of you in the room, just mark your calendars. You will hear from me because I'm gonna need your help. Some of the other programs, we are also working on a cultural competency piece of African Nova Scotian history that we want to make mandatory for all lawyers to have to take. We know that that is being done in a law school currently, but there are many lawyers who have never had any type of education in African Nova Scotian history. And we, of course, as we are talking about IRCAs and their importance and policy changes, how it is important that lawyers understand the history, understand the struggles, and that they are culturally competent, because the Barristers Society, we, yes, are the legal regulators, but our mandate is to be, to uphold and work with and for community. And that is what our mandate is. So if we are gonna work for community as legal professionals, then we need to understand the community which we work for. And the final one, I can't even remember what it left me. I'll leave it at those two, because the third one's gone now, sorry.
Thank you very much for that. I'm happy to hear that the Barrister Society is taking on these initiatives to help improve representation at the Barrister Society and just in the profession in general. Of course, giving students an opportunity to see lawyers and judges and other legal professionals who reflect them and who look like them will be huge in reshaping our justice system. So let's get into it. Rick, and I apologize, I have the questions listed by first name, so forgive me. I keep trying to remember to switch it in my head. But Mr. Woodburn, if you could provide us with an overview of the policy and why it was implemented.
Absolutely, you can certainly call me Rick. We're comfortable here, I think, or getting more comfortable, hopefully. The policy is a result of years of work at the PPS. We started maybe 4 years ago, and I can't say I was involved at that particular time. I think David Curry certainly had a big role in creating the policy, and along with Joseph McKinney, Ingrid Brody, and the rest of our ED&I and A team. And we went through several iterations of it and to get it right. I think it's true to say if we want to run, we can make the mistakes. If we take it slow, we can get it right. And that's what we did. We sent it out to the community. Brandon was able to review it and take a look at it, send us back comments. Shell Williams from Dal also, and others from the community and Defense Bar all had an opportunity. It wasn't something where the PPS was going to foist this on community. We wanted community involvement and still do want community involvement because that's who it's for. It's not for the PPS, it's for your community. And that's important distinction. Some of our policies guide us and tell us what to do. This tells us what to do, but it's for your community. It's rolled out for your community. And that's an important distinction, I think. What is it? Well, when we rolled it out in February of this year, we wanted to make sure that it showed intention. It showed what we wanted to show, that we wanted to show there's some transparency. And that we understood systemic racism exists in our justice system. And that we had the responsibility to take those steps forward and take those steps forward with the guidance of community, not just us, guidance of the community. It starts off, it's almost, don't want to say full service, but it starts right at the early stages of the prosecutions. And some of it's meant to deal with the overrepresentation of African Nova Scotians in our prison system and in our justice system. And you say to yourself, how does that happen? Well, the policy looks at pre-charge. That's where we start, pre-charge, because we can give advice on charges before they come out. That's part of our job. We don't lay the charges, but we can be consulted by the police. And the police do and have brought charges to us. and asked us to consult. I was one of the individuals who was on the, gave the advice for the hate crime unit when it was first brought into, for the Halifax Regional Police. They would call us, for example. So pre-charge, and what we could answer those questions based on training we had. So right at pre-charge, we can make those important decisions by giving advice to the police about the charges that they're thinking about laying, about the charges that bring your community into the justice system, that start that cycle where you're just in the cycle. But it can be stopped. Right at the very beginning, it can be stopped, it can be halted. That's one of the ways. We move into the next stage, which is basically the arraignment or bail stage. So there's two different stages there, depending on if they're brought in without bail. The bail stage, for example, what kind of changes could we make there? What kind of positive changes could we make there? Well, what's important when you're looking at a bail plan for somebody who's being brought in? Community. Community is important because we want to know, ensure public safety, because that's part of our goal, but we also want to make sure that we take into account the individual that we have before us and their history within the system, and their history in Nova Scotia. And community comes in part of that. And it's interesting that I have a story about one of these times that myself and Kai, as a defense lawyer, we were in bail court, and he was an excellent advocate, not only for his client but for his community. And we had a particularly serious charge, and a young African Nova Scotian male. And if anybody knows anything about me, I can be a little hard-nosed, maybe. He took me aside and said, look, he says, you may, with my community, with our community, you have to understand family is everything. The mamas are important, yes, but the grandmas, watch out for the grandmas. And he brought in grandma, and we sat down and we talked, Kai and her and I, about what we can do to have that goal, community safety for us, and release. How do we do that? Well, I talked to her for about 15 minutes, and then I looked over at Kai, and I said, are you sure he still wants to be released? Because his grandmother was going to take care of him way better than any prison system and make sure he wasn't going to leave the house. I kind of felt bad for him. And I'll tell you this, I never saw him again, right? Because we use that notion of community, okay? But that lens that I had to look through, he helped me with. That lens to see something different than my face in the mirror. He helped me. And that's part of what we see with this policy. We are going to look through that lens when we assess somebody for bail. And moving through the trial proper, are we looking at something? Are we going to assess through that lens? And how do we do that? Well, I certainly can't do that myself because I need help. We have a committee. We also have panel members. So if I have questions about that, we can assemble a panel, go back, and we can have these discussions. Here's the case. Here's what it looks like. What do we have? What kind of changes can I make? What kind of biases or unconscious biases do I have coming into this prosecution? And what can I do to change that? What can I do to change that? How does it affect this case? And we get that. That's the trial proper. If we make it through the trial proper, once again, we have an advocate for the individual, of course, the Crown. There's a judge. So we do have some transparency. And remember, the court process is an open system. So we can, all our disclosure is turned over to defense. All of it, everything. They know what we know, probably a lot more. In Brandon's case, he always knows more than me. But when we look at it, it's an open court process. We make it through the trial, there's a decision. If it's acquittal, okay? That makes no difference to me. I move on. That's the objectivity. right? We're not out to win or lose. We present the evidence, we get the verdict. On sentencing, okay, that's when we can bring IRCAs in, and we get that history, specific history, and the historical context in which, and the community in which this individual grew up in. And that can lead a different sentence, and has led different sentences. We look at Anderson. And of course, ultimately, in the rehabilitation and suggestions for how to rehabilitate this person. What are we looking at? What are the suggestions? And we pull those out of those IRCAs. So as we see in the policy itself, once again, we put it up there to be intentional and transparent. We heard about accountability. That's going to be a question that's going to be asked. What kind of accountability? Well, we work in a transparent system whereby we have this policy. We also have leadership, Crown attorneys, and an EDI and A committee, and a panel, all following up. There's also internal and external complaint processes, if none of that happens to be working. So there is some accountability. I have a lot more to say. I think I rounded up a couple of my questions all at once. But I hope that gives you an idea of the policy itself and why we rolled it out and why we think it's going to hopefully make some changes. I heard somebody say, the panel members this morning, to say that this could be a catalyst for change. And I believe that. I believe that this is a catalyst for change. And that's what I'm hoping for. Thank you.
Mr. Rolle and Ms. Fells, I'll invite each of you to answer a couple of questions in turn. If you need me to restate the questions, just let me know, because it's a three-parter. So, yeah. First is, I'm curious what your reaction to the release of the policy is, and then what is the value of this policy to the community and the justice system, and is this something that the community asked for or needed?
So I think it's important to understand how much power Crown attorneys hold. I think Mr. Woodburn touched on that earlier, but it goes right from the very beginning of the process. Pre-charge advice to police. They can decide whether or not to prosecute. They can decide whether to refer to restorative justice. So all these ways to get someone out of the criminal justice system at the front end, Crown can hold the keys to that. And so the idea of FTANs is extremely exciting and promising. But the reality and the perception of community is that sometimes it feels like Crown attorneys are out to win or lose, and that's not their job, and I understand that. That's not what they're supposed to do, but I'm telling you what the perception is from community and what we see and what we have called out publicly on occasion is that it appears that way. And so when we have a policy like this, which was drafted and written by people with a deep understanding of these issues, the hope is that not one African Nova Scotian person would be prosecuted by someone from PPS who does not grasp the historical context in this province, does not grasp the importance of African Nova Scotians being overrepresented in the justice system and in custody. They should not have that power unless they are fully informed with that context. And that is the vehicle, the policy. The vehicle is the policy to get us there, but the hard work is yet to be done. How are we going to do that? How are we going to hold PPS accountable in this work? You know, I think about things like community engagement. This is a great step. The directors in the community. We look at the judges who have judicial independence and have gone out into community on 3 separate occasions to say, how can we serve you better in community? They have judicial independence. They're grappling with some of those same issues, but they have a presence in community and they're talking directly to community. You know, what is the community liaison mechanism within PPS that's going to allow for those types of discussions? I don't necessarily see that reflected in the policy. So if we look at the specific language, it is, you know, from start to finish, which I think is important. We're going to elevate the voice of African Nova Scotians throughout this process from start to finish. But who are we relying on to give us that advice? And so if the guidance in the policy is, well, you should go ask your chief crown, or you should go ask the Equity and Diversity Committee, having a real critical look at the knowledge base of those folks when it comes to critical race theory, to be able to teach the rest of the service how to do this work in a meaningful way. I think that's a gap that needs to be addressed as well. And so when I think about accountability, I think there's a lot of opportunity. I think this policy, again, very well-meaning, and I think if it's implemented correctly, could make really meaningful change. You know, and this policy came out recently, and I've had the opportunity to test this policy, to say, look, here we have a situation of a client, for example, who had an incident at a school. But leading up to that incident was 10 years of this person being harassed by school officials, or their family being treated differently, or their kids being bullied and nothing being done about it. And none of that context is reflected in the Crown brief summary of the police report that we get. You don't see any of that. So I engaged with the Crown to say, look, here's all the context that you need to know. You can't understand this file unless you understand the racial dynamics that go along with this file. And the Crown in that instance was open to that conversation. We've had discussions with respect to restorative justice, which is another big area in terms of critical needs for African Nova Scotians. So we are going to put this policy to the test, in our daily work. We are, I think, hoping at a high level to continue to meet with PPS about how to do some of that training with some of those high-level folks to make sure that there's that understanding of critical race theory and how that engages when we deal with African Nova Scotian clients. So right now, hopeful. I think the idea of FTANs is powerful, and it can be a mechanism for change, but I'm interested in the hard work that needs to be done to get us there, and interested in community being involved at every stage of that work, not only through events like this, but through official policy mechanisms that allow for those types of discussions. Grappling with prosecutorial independence is something that you'll continue to have to do, but accountability to community when there is that much power involved has to be extremely important. So those would be my thoughts.
And I think that's where the Barristers Society comes in. So as the legal regulator, it is our responsibility to make sure that all lawyers have the appropriate knowledge, competencies to be able to practice law for everybody in society. I think this policy, just like for those who are part of the Barristers Society, we are having a coming to Jesus moment in the Barristers Society. We have admitted our own issues that have been happening in terms of anti-Black racism and systemic racism. And we are anxiously waiting the Ruck report, which is all about discrimination, with a lot of recommendations on how we as an organization need to change to do better, because we as an organization have failed, which also means that we have failed PPS, because we have lawyers who work for PPS who don't have the training that they need to be culturally competent. So we have to have that coming to Jesus moment. And we also need to support PPS with their policy, which I have read, and it is a great policy. The one thing that I would say that I learned actually doing my master's in Afrocentric policy from Robert, one of the first things that he said to us was, policy is not what's penned, it's what's practiced. So while it is written down, and it is a great policy that is written down, how is it being practiced each and every day? It has to be holistic. Just like us, when as I said, we're waiting for the Ruck report to come, it is our whole society that needs to be and will be responsible for that report and implementing those changes. Same as PPS. It needs to be holistic, this policy, and how it is going to be implemented. How is it accountable? A question, again, for ourselves as the Barristers Society and PPS, how are we going to be accountable? Have we done an equity audit? We haven't, but we're doing one, because we need to understand where we're starting from and what our baseline is. So once we start to implement those changes, we can see exactly how it's working. Has PPS done that? I don't know. But we are there as a legal regulator to support that. We are also there to make sure that we're creating measurables for accountability. Are we taking statistics? Do we know what that looks like? For us, I'm not sure yet because I haven't seen all of our recommendations, but I will ask that question for PPS. Are statistics being taken and stats so that we know how this policy is having, or is it having a positive change? That is something that's tangible that you can bring back to community. So when you talk about trust and building that trust, that's how that happens. And again, it's the exact same for us. You know, we have to live it, eat it, breathe it every single day. So again, for the Barristers Society, you know, we'll eat our crow and we will absolutely admit that we have fault in that and that we have to change so that our entire profession can change.
Thank you for that. It sounds like accountability is going to be key here, and monitoring the policy or monitoring the implementation of the policy to make sure that it is living up to the promise that it has the potential to